Okay, thank you everybody. Hi and welcome to today's webinar. We appreciate you logging in and using your time to join us today. The webinar is The Value of Trust, Advocacy Implications from the Report into the Public Trustees, Fees, Charges and Practices. My name is Sammy. I'm the Sector Sustainability Coordinator at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land which we are holding this webinar today. In Brisbane, they're the Turrbal and the Yuggera people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Nations Australians listening today. Speaking of our webinar today, we are joined by Joe from Lawrite and Rebecca from ADA Law. They'll be providing an overview of the key themes and findings of the Public Advocate's report, the Public Trustees' response and observations from the Public Trustees' first forays into organisational and cultural change. You should have been sent a PowerPoint. If you didn't receive that, they will be displayed on the screen, and please feel free to email me after the webinar. I'm more than happy to send them to you. I will also be sending out or putting into the website and sending out the updated version of the slides. We've had some changes this morning. It's been a very busy morning for everybody involved. Today's webinar will include case examples and practical tips to help you advise and advocate for clients who have questions or concerns about the Public Trustees' management of their affairs. I'll hand over to Joe and Rebecca to tell you a little bit more about themselves, and I'll let them speak for themselves when I hand over in a minute. Today's webinar, though, is being recorded, and we'll have the recording available to download either later today or tomorrow. The PowerPoints and the materials obviously have been handed out to everybody who registered. If you've registered in the last couple of hours, I'll resend them after the webinar. They're also available in the GoToWebinar control panel. They will be this afternoon. There's two ways you can ask questions. Number one, you can press the button that looks like a hand. I'll notice and I'll let you know whether or not you can come off mute. The easiest way, though, is to type your question into the chat box underneath. Please feel free to type them as you think of them. You don't need to hold them, and I will either respond in writing or I will hold them off to the end and I will ask our presenters. There will also be 4 polls running today, so please make sure that you put your answers in when they appear on the screen. You'll have about a minute to answer those. That's all from me. I'll hand over now to our presenters and I'll talk to you again at the end of the session. Thanks so much, Joe and Rebecca.
Great, thank you so much, Sam. My name's Joe and I'm joined by my wonderful colleague and co-conspirator, Beck. Hi everyone. It's been great to cross paths with Beck in our different roles over the years, and real pleasure to be presenting this and sharing some knowledge with you today. We'll have our contact details at the end, so feel free to drop us a line or give us a yell if you want to chat about anything that comes up today. So look, today you might be aware, you're probably interested, or you're aware from having signed up to this webinar that the Public Advocate released a really significant report into the Public Trustees' fees and charges. It dropped in March this year. The aim of this webinar is to share some relevant learnings for CLC workers. Because of the time constraints, we are scoping this really narrowly. We've had to really narrow our focus to really focus on helping you to spot issues that clients who are presenting to your services, who have the public trustee appointed, help you spot issues that they may present with so that you can better triage, respond and refer. We won't have the opportunity to cover in any depth, and this is not a summary of the OPA's report, which looks at many really interesting broader issues, systemic issues, policies and procedures, political and cultural drivers. And we won't have, unfortunately, the opportunity to also cover the Public Trustees' response or its reform agenda. And we really invite and welcome and encourage you all to have a read of that in your own time. I'd also like to acknowledge that we're very lucky to actually be joined by the Public Advocate herself, Mary, who's registered for and is on this webinar. And we've had a chat and she said she's happy to answer any questions that you might have to her, and we might throw to her at the end of the session if there's any particular questions that she's best placed to address. But welcome, Mary, and welcome everyone today. It's really great to share the space with you. So what we're going to propose to cover in this webinar, we break into two parts. I'll cover part one and Beck will handle part two. I'm just going to overview the Public Advocates Report, a little bit of info for folks who are new to the Data Administration jurisdiction about the Public Trustee and how they come to be appointed. And I'll overview the key issues in sort of two parts. One focusing on the fees that disproportionately affect certain clients, and then other concerning practices that might affect all clients irrespective of their financial position. Before we go into the content though, I think we had a few questions just to kind of see where people are at and see how you're feeling about the topic, and that will help us. So Sam, would you mind taking over there to work your magic?
I sure can. So poll number one, I'm just quickly going through and troubleshooting with some people. Please give me 2 seconds. Okay, here we go. Poll number one is being launched now. It says, who is attending? Are you A, a CLC lawyer, a CLC worker, private practitioner lawyer, social worker, or a public service employee? Give you about another 10 seconds to respond. Thank you so much, guys. It looks like most of the people who are listening at the moment are CLC lawyers, and we've got a fair few public service employees as well. I'm just going to launch another poll now. Number two, how much experience do you have helping clients deal with public trustee issues or seeking their removal? None, a little, reasonable amount, or a lot? Just pop your answers in on the screen for me. Got about 20 seconds left. All right, thank you so much. I'll just share the results now. Most people have got a little bit of experience. Poll number three. If you answered none or a little to question two, where do you refer these clients to? The public trustee, a CLC, social worker or a caseworker, Qcat or the ombudsman, or no one? We're not quite sure where to go. About 20 seconds. All right, I'm going to close it now and share the results. Most are a public trustee or a CLC, Qcat or an ombudsman. All right, last one. Do you have any experience in requesting capacity assessments? None, a little, a reasonable amount, or a lot? About 20 seconds. Pop your answers in. Perfect. None or a little. All right, wonderful presenters. I'll hand back to you.
Thanks so much. Thank you everyone for throwing your answers in there. It's really interesting to see where the balance is and sort of also help us hopefully pitch this at the right level. So look, just really high level introduction. So the Public Advocate's report was a review that was run by the Public Advocate and her office from about mid-2018 to January 2021. The genesis of the report was that the Public Advocate had received over many years concerns and inquiries from people under financial administration, their families and supporters about the PT's fees and charges and the impact on their lives and wellbeing. People in the cohort that the Public Advocate was seeing had often quite modest assets. For example, they had a home, a bit of superannuation, and or like limited income, and were on the disability or age pension. And they'd sort of established sort of their sort of assets and their income with the expectation that it would sustain them and support their lifestyle well into the future. And the Public Advocate found from just an initial review of those who had approached her office that the PT's fees and charges were having a significant negative impact on their financial and personal wellbeing. In the first chapter, it covers two case studies of Tony and Ella who paid $30,000 and $70,000 in fees and charges over approximately a 2-year period of administration. Both of those individuals, Tony and Ella, were able to successfully challenge and remove the Public Trustee, but those practices prompted the question of what happens to people who don't have family and supports to advocate for them. Also, interestingly, looking at stats from the Queensland Ombudsman's annual reports, the Public Trustee has been the most complained about statutory authority in 8 of the past 10 years. So having looked at this, she commenced an initial sort of review using information notices to obtain information from the Public Trustee about their fees, policies, practices, and putting scenarios to them to see what the response would be, and also investigating different particular matters and inspecting files. There wasn't a public consultation process or submissions because of the scope of the review and the resources of the office, but it did result in a really extensive report that was tabled in March, and there's some links to the full report, the executive summary, and a handy video for those who prefer to receive information in that way. So I encourage you to have a look at those. So a little bit of an overview as well for those who may not be as familiar with the administration jurisdiction. The Public Trustee can come to be appointed as financial administrator by normally one of two ways, either under an enduring power of attorney, where a person makes an PLA, appointing the Public Trustee, or they're appointed by an order of Qcat. Now, mostly folks under Public Trustee administration, my understanding is they're appointed by Qcat, and in order to make a decision, Qcat has to make a finding that the adult lacks capacity to make decisions for financial matters. That needs to be based on evidence, usually a medical report, and they also have to be satisfied that there's a need for an administrator to be appointed, in the sense that without an administrator appointed, the adult's likely to do something that involves an unreasonable risk to their health, welfare or property, and it all comes from the Guardianship Administration Act. Once appointed, an administrator has very broad powers. That's to do anything the adult would be able to do with their property and legal matters if they had capacity. And those powers are to the exclusion of the adult. The adult can't simultaneously also make decisions during the period of administration. An appointment may be interim or a final appointment. Interim appointments are generally for 6 months, but a final appointment can be indefinite. And generally, more often than not, from my practice experience, I've seen that Qcat appoints, when they appoint the Public Trustee, it is an indefinite appointment and it's just until further order. So in order to initiate a review of that order, the adult or a family or friend would have to apply for a review or a declaration of capacity or the appointment of an alternative administrator. Is that your practice as well, Beck? More of a mix?
We get more of a mix, I would say, but typically a Public Trust appointment is a plenary order, so it's over all of your financial and legal matters relating to your financial, as opposed to a guardianship appointment, which may be over a specific area of your life.
Good point. And I should also note as well, you know, we're you're sharing this knowledge from the Public Advocate's report, but also from our own practice experiences. They're not necessarily representative of all, you know, clients under administration, but hopefully provide some useful sort of thinking and talking points. All right, so the Public Trustee has been in place for over 100 years. was established in 1960 as a public curator and established as a self-funding organisation. Administration for clients under an appointment or a GPO is EPO is a significant part of their business. They provide administration services for about 10,000 clients. You might also be familiar with their free will service, and in approximately 25,000 wills each annual year, and that's a growing service. They also manage deceased estates and other trusts. And I suppose it's really important to note that while there are some concerns about fees and charges and practices, really important to note that the vast majority of PT clients do pay low or no fees for the services that the PT provides, and they appear to receive a reasonable level of service, and that the public trustee is and will remain a really important service for clients whose capacity to manage their own affairs is limited and don't have appropriate family supports to provide them those services. So in my section, I wanted to sort of break down some of the key concerns identified by the public advocate in sort of two sections. So that is that looking at first the cohort of clients who I'll call the cohort vulnerable to high fees, and those are those clients whose modest assets make them ineligible for fee rebates, but whose low incomes aren't sufficient to absorb the public trustee's fees. For this cohort, the PT's fees may exceed their income, and the application of those fees may erode their cash assets within a number of years. The PT estimates that this is not a significant proportion of their clients, and have estimated it to be only approximately 4% of their clients. The second set of issues that may affect this cohort, but also a broader range of clients who you might be seeing in your services, sort of relate to the sort of practices and culture in terms of, decision making and failure to consider the adult's individual circumstances. And I'll also cover under that section concerns about external financial advice and the involvement of the official solicitor. We're going to cover this in a really high level way just to help you to spot issues rather than sort of delve deep into understanding, how that might play out for your clients. So first up, looking at that impact of the fees. So this table is extracted from the Public Advocate's report and shows some of the different impacts of the sort of standard public trustee fees and charges on 4 different clients with different mix of assets, both real estate and cash. And you can see that there's quite a difference in terms of the fees payable and how quickly that will erode their cash assets over a period of years. And for some, it's really sustainable. 45, 59 years or over a lifetime could be quite a sustainable fee to manage. But for certain clients, the application of the public trustee's fees may erode their cash assets very quickly in as little as 7 years. We'll go through the standard fees and charges. There's some really great information in the Public Trustees report setting out different tables and graphs, and I haven't included that in this slideshow so as not to go down the rabbit hole, but I do encourage you to have a look at the Public Advocate's report to get a better handle on it, or if the issue does come up, to better understand it. So the first is the personal financial administration fee, and that covers the general administration services. That's a scale of fees depending on where the client resides, what level of support they have, and the frequency of contact with the public trustee. It varies from $1,300 for those who are in aged care, residential aged care, and up to $9,000 for those who are living in the community. Approximately 60% of PT clients on the highest 2 fee levels and pay either $6,500 or $9,000, which represents about 30 to 40% of the DSP. The next standard fee is an asset management fee, and that's calculated on the value of the client's assets, excluding their home, personal and household items, and motor vehicles. And that can be between $200 up to $13,000 for assets over $2.5 million. And then there's a real estate property fee, which is a flat rate of $979, which is charged annually. So we've included here some sample documents that might just help you to recognise or see where to look for these different fees if a client walks through your door or brings their statements to you for advice. So every year the Public Trustee will deliver a statement of assets and liabilities, which sets up the client's assets and liabilities, as you can see. They'll prepare an annual budget every year, and you can see that there's under income, a pension, a small amount of interest, and under the expenses, there'll be different categories, including chemist, clothing, living expenses, outlays for things like postage, faxes, phone calls, and then there's the public trustee fees. It can sometimes be quite confusing because both in the annual budget and in client statements, the fee is shown and then the rebate is shown separately, and that can be really confusing for clients who may not understand that, look, they might be charged, it might look like they're being charged $2,000 for their fee, but they've actually been given a $1,000 rebate, so they're only paying $1,000, or maybe even much less, and it does vary a lot. So important to help clients sort of navigate and really give them a summary of exactly how much they're paying. The public trustee is working on more user-friendly statements that are more easy to see, like, like you see in a lot of our utilities bills that have really clear information about how much is owed, how much is there, and in much clearer communication, and that was one of the key recommendations of the report as well. There's also these statement of transactions. I've highlighted this because there'll be some standard transactions, but then some of the additional outlays, for example, for additional services fees or financial advice or the official solicitor's fees, may not be disclosed in the annual budget and may not even be disclosed to the client, most likely not. And the only time that the client will realise is if they actually look through their statement of transactions and see a withdrawal. So you can see we've highlighted the withdrawal for official solicitor's fees there. I'd also note that I didn't include this in the slide, but in the budget, there's also some comments on the budget, and there needs to be an annual budget review. The comments to this particular budget for this client who lived in a nursing home, it reads that the budget was reviewed with the accounts receivable officer who confirmed the budget is correct and meets the client's needs. It noted some updates to the pension and fees and had regard to human rights. But looking at those notes, it's really important source of information because you can see that the public trustee actually, no evidence that the trust officer actually consulted with the client in developing this budget. So look not just at the budget, but then the notes page, because that can be really useful information about whether or not, how things are actually looking in practice. Do you have any other comments on that, Beck?
Not really, other than it's the point is that the client engagement, which is typically our clients are getting very frustrated because they see that the public trust has taken over and they don't quite recognise that it is still their funds, and the role of the public trust is misunderstood, and a lot of that is the lack of communication and engagement directly with the client. We'll talk a bit more about that later on, but essentially it really is on the public trustee, case officers to engage with the client at the client's level, and whichever way of communication is best. So sometimes that is having to be face-to-face. Other times it's using pictures and so forth. So it's something that the public trust, I think, has taken on board that they need to be better at engaging with. If for nothing else, then to give some peace of mind to some clients about what is happening with their funds.
Just briefly back on the concerns that clients might have with these fees might be sort of twofold. In the personal financial administration fee, while they're set as a proxy for the level of complexity and the level of contact the client might have with the PT, that might not actually be reflected in what's in practice, and so your client might be considering whether or not that's an appropriate level of fee for their actual circumstances and how frequently they're contacting the public trustee. And also, particularly with the asset management fee, the public advocate raised concerns that many clients actually have a really narrow range of assets. They're managed really conservatively and very little changes year to year. And it's not really clear what services are being provided for the yearly asset management fee. And so there were some concerns that it was a sort of set and forget situation. So you might want to drill down to, well, the charges fee annually, what work is actually done for that level of fee. Some other fees, outlays and income just to be aware of, so there's additional services fees which we charge for the trust officer doing additional work in relation to debts or collections or payments, providing instructions to legal services or attending to complex financial matters. The public advocate found examples though where the additional services fee was charged for routine activities. So take a close look at those additional services fees and whether they really arguably should be within those headline annual fees. Fees on investment funds. So where clients do have sort of cash assets above sort of a minimum level, they can be invested in the growth trust. And that's a trust where the public trustee, it's actually managed by QIC, but the public trustee also charges an additional 1.5%. So that raised concerns in the public advocate's reports about double charging. The interest differential. So by pooling clients' cash assets and investing in the growth trust, as I mentioned, the PT is able to achieve greater returns than the clients might be able to through sort of commercial alternative investment avenues. The public trustee pays clients a prescribed rate of return that's between 2.5% and 4%, and it retains the difference. Now, the public trustee hasn't published the interest it returns, but the public advocate looked at the annual report comparing earnings from interest revenue against interest expenses and suggested that the public trustee could be retaining as much as 62% of its clients' interest earnings. And there's also the concern looking at those annual reports that the public trustee appears to have been banking operating surpluses over many years, in fact, in all but 3 of the last 20 years. And over that 20 years, their reserve has more than doubled from 82 million to 178 million. So it's unclear whether that practice of retaining that interest and those profits is consistent with the public trustee's duties as a fiduciary. Another issue that was picked up is that whilst the New South Wales trustee thought a ruling from the ATO that recognised that financial management fees are exempt from GST, that hasn't happened in Queensland. So effectively, people under financial administration in Queensland are paying 10% more than their southern counterparts. Concerns outlays, which can be very reasonable for valuations, building personal property inspections. They're generally unproblematic if reasonably applied, but outlays also cover things like financial advice and official solicitors' fees. I would also note that you might have seen in that those budget papers that incidental outlays for postage, faxes and phone calls. Anyone who's been in private practice may know that lawyers aren't permitted to charge general fees for incidental outlays. They actually have to be accurately costed, and the PT hasn't been following that practice. I'm mindful about time, so I might just cover this really, really briefly. So with financial advice, key concern was that there's only a single external provider of financial advice, and that clients with quote unquote complex assets are referred for financial advice every year. That can be really sort of concerning because complex asset is defined to include super. So someone could have only $2,000 of cash and $2,000 in super, and they're paying several $100s for financial advice every year. And it's clients aren't consulted about whether or not they want financial advice. Official solicitor fees, I really encourage everyone to have a read of Chapter 7 of the Public Advocate's report, but basically the public trustee operates an in-house team of lawyers who perform legal work for clients but charge and practice at commercial rates, but there's no cost disclosure to clients or family, and there's no there's evidence that those lawyers don't really weigh the costs of obtaining legal advice against outcomes. There's no real kind of cost-benefit analysis. So if you see, for example, in that statement transactions, official solicitors' fees being withdrawn, do ask questions about the services that are being provided. One of the challenges is that, so a lot of clients do receive fee rebates. They're called community services obligations. The concern though is that the value, unlike in Centrelink, the value of the person's home isn't included when calculating the value of the person's home is included when calculating eligibility to receive rebates. And unfortunately the level of assets is set very low. The PT also has a manual directing trust officers consider whether to make a claim on a client's super in order to pay their fees, which can have really deleterious impacts on clients. Look, Beck's mentioned some other concerning practices like failure to consult and involve the decision-making practices, decision-making valued considerations, there's circumstances. Those rebates I mentioned aren't automatically applied. It requires a trust officer to actually make an application. So, you know, every system that relies on humans will involve error and human fallibility. So definitely have a look about whether your client's getting a rebate that they're entitled to. And also things like you were telling me that simple processes like automatic regular transfers are done manually rather than by setting up electronic funds transfers.
That's my belief. Yes. Yeah. So you know, your regular $50 on a Friday, someone's actually keyed that in every week to make sure you get your $50 each Friday. And they're doing that every week. So
you think there might be some
quite
really
an annual process at the moment.
And could be some cost savings and that could be passed on to clients if there were some updates to
those automations. Yeah.
Yeah. There's a case study of Brian. I mean, the key point to this case study, and I won't go into too much detail, the details are on the slide, but he challenged his, he sought to challenge his appointment in Qcat, and the official solicitor made written submissions that were not helpful, in fact, made very technical arguments against his application, certainly not in his interests, and charged him $2,500 for the privilege. So that, you know, highlights a few concerns about the official solicitors not really clear who the client is in that situation, and those costs certainly weren't disclosed to Brian or Qcat, and emerged later on when he was reviewing, when the order had been revoked, he was reviewing his financial position. I'm going to jump to some potential service responses for the sector. So a few areas that you might be able to assist your clients. Firstly is in just accessing and understanding information. You've seen with some of those documents that they're not very easy to understand. Being able to help, if your service has capacity, a lawyer or one of your other workers, to be able to help them understand and navigate and translate that information so that they can understand their financial position. The other thing is that I saw in the Public Trustees' response that they are considering or going to initiate a practice of enabling clients to inspect their files at the local trust office. You can also access information on behalf of the client. I understand your experience, Beck, was that if you have a signed authority to act, you haven't had any pushback on that. So, so just be able to, information and knowledge is power, so that can be a really useful thing that you can do for your clients, both to help them understand and also for the public trustee to see that there's someone else looking over their shoulder as well. So that can be really powerful. If your client does have some concerns with either specific fees or with decision-making practices, they can raise that with the trust officer, and there's also an internal complaints line. There's a new customer advocate position that the public trustee has put in place, which Beck will talk a bit more about. There's also some external complaints avenues, and I suppose almost every organisation has a complaints line, but the public trustee has a bit of a different position, is in a difficult position because in responding to complaints about their own administration, they are in a position of conflict, and there isn't the existing complaints process doesn't really, in our view, properly address that conflict. And so I suppose the point of the note for services is if you are experiencing, or your client is experiencing difficulty with these internal complaints responses, there is also the option to escalate that to the Ombudsman, right to the Attorney General, especially to note the experience, but also those systemic issues. You can have a look at the Public Advocate's report to inform those complaints as well. Also, if you've had some visibility of some of the legal services that might have been provided by the official solicitor and have concerns or complaints, there's the option to make a complaint to Legal Services Commission. The client can't actually do that themselves because public trust lawyers that work for the public trustee are government legal officers, so only another public service employee or another lawyer can make a complaint, but that may be an option that might be required. The final point, and before I hand over to you, Beck, is have a think about whether you can give advice or there are some issues regarding breaches of duties and entitlement to compensation. The public trustee is doing a lot of work on the reform front, and we'll talk about that a little bit more. But you know, these practices have been going for many, many years, and there may be an entitlement to compensation in some of these areas. I will say that with a big asterisk and a big disclaimer in that this is not really fully tested yet, or hasn't, when there's no test case, or it's not been, you know, it's not a well-worn path in Qcat, but there is the option to apply to Qcat for a compensation order. So, you know, have a think about that as an option. And if you are going down that path or have any success, please let us know. I'd love to share that knowledge. All right, I'm going to have it.
Thank you, Jo. That's awesome. So I'm taking on the second part of this session, which is more about some on the ground type of practices that we've been working through. So the first thing is for anyone's general knowledge about how to review the appointment of public trust. So that's a Qcat process, and it requires that the Form 10, which is an application for review, is completed, and the client will also require a health professional report. Qcat have recently upgraded their forms in that regard, so make sure you're using the most recent health form, and also think about which is the appropriate health practitioner to send your client to, taking on board their possible cognitive impairments, which is the right specialty to give them the most use in a report. Depending on the outcome of that report is usually when we think about whether we're going to do a Form 11 declaration of capacity or not. And sometimes that's the extra step that clients are looking for, because they can maybe get rid of the public trust, but then they still don't get recognised in their own right as a decision maker. So sometimes that extra step is really very useful. So once you've lodged these forms, it takes Qcat around about 12 weeks in normal times for a hearing to be set. And they give generally, I'd say 2 to 3 weeks notice. And we always recommend that our clients attend their hearings in person. It always gives people their best chance at being heard and valued and participating in their own outcomes. And often our clients report that they didn't know this was happening to them, and they weren't part of the hearing, and everyone can get a little bit doubtful if that's the reality of maybe they've forgotten. But in actual fact, many clients have literally gone through this entire process and been completely unaware of it. And the first time they find out that they have a decision maker is when they go to the bank to try to take out money, and then they're told, sorry, you've got the public trust, you need to speak to them about that. So we always say to our clients, get there, put your face in front of the tribunal and be seen and be heard. So when you're doing that and you're looking to proceed to the Qcat, we also think about being mindful that is the client perhaps going to be facing some additional public trust fees if the official solicitor is needing to be involved in the hearings or procedures. And if that's likely to be the case, we'd be looking to get some disclosure about that so that the client is aware that they're looking at maybe a couple of $1,000s or more in fees for this process. There's more of that information in the Public Advocate's report. So our experience in the past year with the Public Trust is that they have been implementing a number of changes, particularly aimed at improving the client experience. So the introduction of their consumer advocate role, which is, as Jo was saying before, a bit analogous to a complaints department, but they do also have an additional focus where they're working on trying to improve their staff culture and their education for their staff. And we have started noticing some changes in that front. They're telling us that they're working towards training staff in supported decision-making strategies. And we haven't actually seen the resources that they're using in this space as yet. But we're quite hopeful that this training will be teaching their staff how to speak to their clients more usefully, how to engage with clients in a variety of ways. So not all of our clients will answer a phone call when it's got a no caller ID. So sometimes it's a text message that's required. Sometimes it's a bit of lateral thinking. Sometimes it's face-to-face. Sometimes it's sending a letter. We're looking at hoping that case officers become more adept at adjusting on a client-by-client basis to accommodate those different needs. And most importantly, that they're looking at the client's rights and they're operating in a least restrictive approach. which is underpinned in the legislation. So looking at helping a client perhaps learn some financial literacy for themselves, and then setting up their finances with them so that it can be more straightforward going forward, and perhaps using a philosophy about trying to do yourself out of a job occasionally would be really useful for many clients. That's right. Okay. Other strategies that they're looking at doing is they're putting together some reference groups which are using various stakeholders in this area, and they're taking their feedback on that. So the rest of that's really in the blurb there on that page. So I'm just going to talk through a couple of case examples of people that we've had mixed experiences with in the recent times. So Joseph was one of our clients who, against his wishes, was moved into an aged care facility. There was a subsequent Qcat hearing that the Public Trust didn't participate in, but he was recognised by Qcat to have his own decision-making capacity for his personal decisions. So the public guardian was removed and Public Trust was kept in place. He subsequently approached the Public Trust to say, I want to go home, I'd like you to get my house ready for me to return, and that will require some repairs, which he had the funds for. Unfortunately, his trust officer wasn't cooperating with these requests, and months had passed. During that time, he was also accruing debts at the aged care facility because there was some problems with reporting at Centrelink and other things that we'd been expecting Public Trust were dealing with. He then received notices of eviction from the aged care facility due to the unpaid invoices, and throughout, unfortunately, his trust officers weren't really being that responsive to him. We then got engaged and sought the intervention of this new role, the consumer advocate, who brought in the regional manager and the executive director, all of whom recognised that actually he does have right to make his own decisions, and that it isn't the Public Trust's responsibility to determine, let alone his capacity, but also to rehear a finalised Qcat matter. And so we, with them, were able to get progress to change, and he did eventually get to return home. So that's an outcome that we probably wouldn't have seen maybe a year or so ago. A similar story is William, who's a middle-aged man with mental health history. He became vulnerable after his partner died, and he was very generous and good-natured and trying to help others who had less than him. That led to him being exploited, his pension was getting taken, he was left with debts, and his mail and his phone were also being taken by people. So there was no safe way to communicate with him other than face-to-face. And that point was made very clearly at the tribunal hearing, that he does need the Public Trust and they're the only appropriate decision maker for him, but they need to go the extra yard and do the face-to-face. Unfortunately, that didn't get picked up quite so quickly, and it was many months of everyone wondering when's this going to take place. We ended up intervening further with the consumer advocate, who again escalated it up the line, and then they did recognise that they did need to be a bit creative in their engagement with him, and we managed to get face-to-face at his home, which was a bit of a revelation for a few folk. And, you know, they were, from that point forward, working really well with him and helping him, you know, get a phone that was safe, and all sorts of other practical measures to help him reconnect. And just my last example is Auntie Doris, who had, and this is another really familiar story for lots of people, but had several children. They'd fallen out with each other. Some of them had fallen out with her. She subsequently had a stroke and took turns living with one child after another, and it ultimately, you know, things went sour. The kids became unbearable for her, and she sent them some legal letters to tell them to stay away. The children got the public guardian involved. They alleged that she had impaired capacity and that she was vulnerable to undue influence of one of their siblings. She was then placed in an aged care facility, and Public Trust and Public Guardian were both appointed. Throughout that time in the aged care facility, however, the Public Trust hadn't been paying her fees at the aged care facility. So when she subsequently had everyone removed at the Qcat hearing, the very first day that she was free of the Qcat hearing, she went and moved home to her daughter's house, but then started getting legal notices from the nursing home to say, you owe us all this money, what's going on? We contacted the public, she contacted the Public Trust to find out what was going on and get them to step in and get involved. At that stage, they'd said, well, we've been removed, we can't do anything. And that was a particularly common line that we used to hear a bit of. Once, from the minute you walked out of your tribunal hearing, the Public Trust wouldn't be available to help you unpick some knots. Modern times, though, we were able to engage with the consumer advocate, and they have subsequently been involved and now have agreed to help Auntie Doris and her daughter resolve those issues. So again, another change that I think is a positive change in their practices. How are we going for time? We're probably
we've got a few more minutes left.
Okay, all right. So that's just some examples. They're pretty bread and butter for the work that we do. We see those sorts of cases fairly regularly. And I guess it gives us some more experience about what changes we want to continue to see in this space. So supported decision making is absolutely a must. And if in a certain client's case that means referring the client to a financial literacy course, then that would be something we would really encourage. Getting your clients to work with financial counsellors, using pictures, using drawings, using videos, whatever sort of way you need to communicate with your client and getting them involved in their decisions is things that we'd like to see. Again, we think that they need to do a significant investment in technology. So using computer to text messaging, home visits, learning some soft communication skills. So how to de-escalate a client, particularly clients with certain cognitive impairments. They tend to rapidly escalate, and if they're told no, it just ends badly. So looking at some skills and appropriate education for staff to manage that appropriately. Ensuring that there's an engagement directly with the client is so fundamental. And we want to see a lot less of them just speaking to the facility manager or just speaking to the accounts department, and more of, you know, we spoke to this client, we visited him at such and such, or we met with him here or there, and these are his goals, and these are the views, and this is what we can do to assist. Setting up automatic bill paying, making the most of things like centre pay and direct debits and things, so that a person is more easily able to take back control for themselves once things are in place. All of those sorts of things are very practical, and if you or I are managing someone's finances, it's the first thing we do is look to make it as easy as possible. So we'd like to see a bit more of that. Obviously, the reviews of fees and charges has to be more transparent. These statements need to be readable. It shouldn't take you sitting down with an Excel spreadsheet and a calculator to figure out what your fees are and making sure that you can afford your next packet of cigarettes or whatever it is. Yeah, I would just like to say though that we have noticed some positive change, and we remain optimistic that that will continue with further engagement.
So I suppose, look, we're just at the tail end of this, and so I suppose a few key takeaways that we thought might be useful just to recap. Is do take a look at Public Advocacy's report and makes 32 really powerful recommendations for change. Do also have a look at the Public Trustee's response. As Beck said, the Public Trustee is seeking to implement a client-focused practice and culture with their customers first agenda. Like any large, long-standing organisation, we can expect that change will take time, and it may be uneven and will require persistence from all parties, both within and without. Adults, even if they do have impaired decision-making capacity, do retain their human rights, and which includes the right to be involved in decisions. Clients can be assisted and encouraged to negotiate with the Public Trustee for more financial independence and engagement. Clients can seek a review of their appointment in Qcat, but do note and be aware of any additional fees. And as I mentioned, this redress for potential breaches of duties and past fees is a live issue. It's not yet been tested, but it's worthy of consideration for your clients. Got Public Trustees provide us with some updated contacts for both general inquiries, complaints, and if you wish to escalate anything to the customer advocate. I've also included contacts for, I suppose, the main community legal centres that work in this area. So ADA, QAI, and ourselves. Their scope of service and contact details are there on the slide. And Beck and I are both very happy to be contacted by CLC workers for secondary consultation. So if you're wanting to have a sounding board or get our thoughts, pick our brain, or to discuss your practice experience, and our contact details are on the last page. And I think we'll go to interested in your thoughts, comments, questions. Thanks so much for your time over and taking time out of your lunch break. Yeah, thanks so much.
Thank you, guys. If you do have any questions, please pop them in the chat for me now, and I will read them out, or I can email them through, or whatever it might be. I'll give you a couple of minutes to pop questions in. And we've just had a message through that OPG pre-advocacy team is happy to be contacted as well.
Oh, thanks so much. Great that you OPG friends have dialed in as well, and perhaps we can update the slides for when they're published on the website with those details as well. So, perhaps you could drop us an email with your best contact details. Thanks, OPG.
We've got one through here from Holly. It says, hi, I missed how much the PTQ charges to clients for their costs of managing client finances.
Yeah. So
the $64,000.
Yeah. As in, so I assume that's around the fees that I covered at the beginning. So they're broken down into different types of fees. There's not just one headline fee, but there's different types of fees for different services, and then there's a range within they're sort of scaled, I suppose, depending on assets.
So the first hierarchy depends on where the client is living. So if they're living in a nursing home, they're on the lowest fee scale. If they're living in the community, they're in the highest fee scale, and there's a variance in between.
Between about $1,500 and $9,000.
Something like that.
That's just for like the core administration services. So the work that the trust office does in setting the budget, making and receiving payments, contacting the client, perhaps. The kind of core business of administration. Yeah, that's that fee.
Yeah. And then depending how much assets the adult has, looks at the other scale of fees and also the numbers of engagement with the client. So typically a client that needs a lot of engagement from Public Trust will be at the top of the fee scales. Someone who's a set and forget type client is usually paying less in transactional type fees.
And then there's all those additional fees. So it really can range, but I suppose the core fees are the financial administration fees, asset management fee, and if they've got a property, a realty fee, but they can also, there'll be various rebates that'll be applied.
Yeah.
So again, that could be anything between, I think you talked about one client who gets the highest level of rebate and is only paying $10 a month, up to clients who might be paying tens of thousands. Well, I mean, for the core fees, it could be $25,000 if they're on the higher scales. But then there's all the additional fees that we talked about, with additional services fees, official solicitors fees, financial advice, external reports, all those sorts of things.
Yeah.
So it's really, it's a bit of a how long is a piece of string, but we're hoping that with this presentation, by giving you some of the terminology, the language, showing you a few statements, might help you to help identify and navigate that a little better. I hope that is helpful.
That's helpful.
Yeah.
Thank you. We have another one here through from Rachel who says, can you appeal the Qcat decisions?
You can appeal at Qcat if it wasn't heard by the senior member or the judge. So if a usual sessional tribunal member hears the matter, then yes, you can raise an appeal with them. If you want to go and it was a senior member, you can appeal to the Supreme Court. Typically appeals we find take, as long as 2 years to be heard. And so our usual go-to is to seek a review. So we get a new medical report. We're looking for a change of circumstances for the adult, and we're looking to get the matter reviewed. And that tends to be a quicker process.
And also the appeals, what proportion are face-to-face and how many are on the paper?
Yeah, I don't really deal with appeals. We don't use our energy on them. But I find most of them, I believe, are on the papers.
So they might not be able to, and they'll just be relying on the original evidence, although you can submit fresh evidence. Might need to double check. Might have to get back to you on that one.
Yeah.
Yeah.
That's okay. We've got one more that's come through. It says, what extra fees are you talking about when applying to Qcat to have the PT removed?
Well, so that would be if the adult has a complex situation, or they're making some sort of allegations around the public trust dealing with some complex financial matters, the public trust may choose to engage their official solicitor in assisting them to explain themselves to the tribunal. And in doing so, will incur some costs that the client pays for. It doesn't happen all the time, and very many cases are going to Qcat to say we want to get rid of the public trust, and it had nothing to do with the official solicitor and there were no charges per se, but it's just something to keep an eye out for.
Something to be aware of, because in our experience, there hasn't been any, all the matters we've seen, there hasn't been any prior disclosure or heads up, I suppose, for either the client or Qcat that was happening. It's taken clients by surprise. And I apologise, I was mindful of time. I didn't want to walk all over Beck's speaking time, so I did skip over that really quickly. But if you look at Brian's case study, which is actually was featured at the same spelling in the Public Advocate's report, I think it's case study number 7 maybe. Have a look at Brian's case study and that chapter 7, because it walks through what that looks like and how it can happen. Again, I understand it's the minority of cases, but those fees can be really significant in the thousands or even tens of thousands of dollars. Hopefully, however, that will change, and I understand that part of the PT's review and reform agenda has also been reviewing the practice of the official solicitor. So hopefully we'll see a change in that area, but just something to be aware of.
That's right. And just a last comment from Mary. The Public Trustee says that it now offers support and training in financial literacy for its clients, and it may be worthwhile asking for your clients to access that program.
Yes, and I'd also encourage practitioners, if they've got a client that wants to get rid of the public trust, it's really hard if they haven't had much experience in demonstrating their own abilities, that we encourage them to say to the trust officer, I want to start paying some bills, and weed them away from the public trust management. So, we often start with the chemist account, or a phone account, or an insurance policy, or something or other. And usually the last stand is the rent bill. That's a good way for a client to be demonstrating some practical experience. Public trust has oversight, so they can still see if there's an overdue notice or whatever. But it helps clients gain some independence and some self-worth as well, and they find it quite rewarding.
I can imagine. That's wonderful. Thank you both so much for your time. I think I've got one more here that says, if they are at fault, would the person still have to pay? So that would be in relation to
if the public trustee was at fault.
I would encourage them to engage with one of the solicitors and seek to get reimbursed, and then they may need to push it a bit further up the line. But certainly, if public trust is at fault, it's absolutely your right to seek to get that money back.
And recommend, asking the public trustee in the first instance, and if you're getting pushed back, again, escalate through those different complaints avenues. An option as well is to apply to Qcat as well, being mindful of fees as well. But yeah, look, I suppose, and just sort of a final comment, really, as I mentioned, change takes time and persistence and will and grit, and we've seen a lot of goodwill from the public trustee. Hopefully that will continue, but we all have a role in supporting our clients to achieve the best outcomes, and we'll hopefully see that change trickle through over the next years. Probably it will take a while, but thank you for your time, all, for in in sharing this with us, and,
Yeah,
and we're really
for the
interested
interest.
and your
Yeah.
interest, and I'm
Yeah.
really interested in hearing your experience and your stories as well.
Wonderful. Thank you both so much. We really appreciate it. Thank you everybody for tuning in, and I'll send through the PowerPoints and also the recordings either at the end of this week or early next week. Thanks, guys.
Thanks, Sam. Bye.